Good morning. Thank you to our speakers this morning. We have Simon Murray of William J. Marshall and Partners. Simon's a chartered architect with 15 years experience in the construction industry. He's worked on a range of architectural projects in the UK and overseas, particularly in Egypt, Germany and the US. He's now acts as a forensic architect, giving expert opinions to tribunals. And our second guest this morning is Catherine Butler of Fenwick Elliott. She's a contentious construction solicitor who advises both contractor and developer clients. She's acted on matters in the TCC, Court of Appeal, and various international arbitrations. She's also wrote a number of articles on the topic of expert shopping, which is how I came across her when we was planning today's session and we asked her to be involved. So without further ado, because as always, we've got a lot to cover in a very short amount of time, we'll start with you, Catherine. And for those who perhaps are not familiar with the topic, what is expert shopping?
Well, putting it very simply, it's the process where an expert is switched. So one expert is replaced by another. And it's normally because the intimation is that the client doesn't like the answer that they've got from their first expert, and so they want to replace them with another. And the courts are very much involved in this, and they are very hard over that it's not okay.
I mean, the reason it's become such a hot topic recently is because the courts have had some things to say about the practice. What are the opinions of the courts?
So a lot of the case law on this sort of comes out in the early 2000s. So it's over the last 20 years that the real sort of principles have been established. And then over the last couple of years, you've seen quite a few cases come before the TCC where those principles have been applied. So basically the practice is that the courts are very interventionist when it comes to expert evidence, because ultimately the duty of the expert is to the court and not to their client. And also for the reasons of proportionality and equality of arms, the judges that have a high level of control over what expert evidence is actually put before the court, and only to the extent that it's needed to resolve the dispute. So when you want to substitute an expert, you have to have the court's permission. Therefore, all these circumstances, client wants to substitute an expert, they have to explain why they want to substitute that expert, and the court has to agree to that substitution. And the case law is developed whereby the court will put conditions on that substitution that the parties then have to agree to. And I think we're going to get onto that a little bit later on, but basically the main principles is that the courts will be very keen to establish if there is expert shopping, or even if there's the strong inference that there's expert shopping. So it's not, don't have to have direct evidence of it, but just that it creates the inference that that's what's going on. They will seek to impose those conditions, and it can be devastating to a client's case if it is in fact that they're trying to get one past the judiciary in terms of I want to put my own forward, I want to put my own case forward.
Simon, as an expert, why is it that expert shopping conflicts so much with your role?
Well, I was thinking about this, and I don't think it necessarily conflicts per se. I think the issue is that it's more of a warning flag for someone who is being approached in the process of a client who is expert shopping. And it's just some items that need to be watched out for in that situation. So essentially, you've got somebody who wants to change their expert. When that happens to you, someone approaches you and says, why, can you replace this other expert? You would want to be sure of the reasons for that. If it was simply that your opinion was a preferable one to the one that had been given before, that puts you in a difficult position. But that's a sort of tricky one to envisage as being apparent, because in the first case, you wouldn't necessarily know what the other expert has said. There's this process where they will have to find out what your opinion is, which potentially is premature if you haven't spent all that time looking at the evidence and producing a more detailed opinion. So really, it's just a case of making sure at any stage that you maintain your independence and you're not trying to say what somebody wants you to say. and equally to convey your views and the uncertainties in your views as early as possible in the process.
Looking at what Simon's saying, Catherine, can it be a grey area? Do you have to take the first opinion that comes along? Because perhaps you think you've got a stronger case than you do. You might want a second opinion from a different expert.
Yes, absolutely. And when you're considering your case, you will consider the merits of your case. And, that is the sort of the crux of the expert role, is to put forward an opinion, and there can be more than one. So at the very outset, my advice would always be, if you feel like there's some stones that haven't been unturned and you've got an expert opinion that you think maybe could be shifted with different information, or you think that they've got it wrong in the most extreme circumstances. But that very much has to be at the outset, before you are sort of putting out the claim, before the pre-action stage, really, in terms of you are just assessing the merits of your position. Because as soon as you do get into that process, it is very much that as soon as an expert is appointed pursuant to CPR 35, their duty is to the court and not you. And therefore, at any point that there are conditions, it can go right back to that first appointment in terms of things that can later come out through disclosure. But I think it shouldn't be a grey area in terms of, I think it should be pretty obvious to people if expert shopping is actually what's going on here, because there are perfectly legitimate reasons to switch an expert. They may be poorly, they may want to retire, and these things are going on far too long. They may be that they've got a diary clash where they have to, they can't be in two places at once and they have to give up the matter. But where none of those things are happening, the sort of conclusion will be that you are getting rid of them for another reason.
And if I can just say from that point of view, I suppose looking at it from the perspective of the expert, you would want to know that it was these other reasons, that, somebody's not feeling very well, obviously, or they can't do it. And it's a little bit awkward to be asking those questions, sort of intervening in areas where it's not really your business, but you do need to satisfy yourself that you're not there as a sort of replacement because you'll say something that they think will be better. As I said before as well, how do they know what you're going to say is any more sort of supportive of their case than what the previous expert said? There is that as well to deal with, but it is this case. It's a high risk, I suppose, for any client who wants to switch their expert, because they've sunk some money, some time, some effort into briefing this one person, discussing it, getting an opinion. And if they then want to shift, rather than sort of discussing the issue and trying to I suppose, align their case with the expert view that they have, or discussing and seeing if there are alternative views that the expert can consider. If they're going to absolutely sort of shift them and move on to somebody else, then you've got this risk that is now increased with the case law, saying, well, actually, you're going to have to disclose that report anyway. And also, as well as all the supportive work. And for an expert stepping into that, there's the difficulty of having to almost second guess what somebody else has previously said, but try and ignore that, so that you're not walking into messy territory that's already been trodden. But equally, you don't want to be getting into what that person has written in their previous report, because you're not, it potentially can be seen to problematize your viewpoint because you've sort of stepped into somebody else's report.
But I think that's an interesting point, particularly about the decision by the client in terms of the amount of time and effort and money that they will have invested in the expert that they've appointed. It really is a sort of a last ditch, last resort to try and seek to replace your expert. And it might, we sort of talk about this being a kind of, it's either perfectly legitimate or completely nefarious. But there is the circumstances which, hope are very rare, In a perfect world, everyone's brilliant at their jobs, but there might be circumstances where a client has simply lost confidence in their expert, and it's not that they have a view that hurts their case. It's simply that they don't want to work with them anymore, or they don't have confidence that they're going to perform in the way that is going to help them, and they might find that someone else with exactly the same opinions would simply perform better. So it's very much that, and the courts have been very clear about this, it's on a case-by-case basis. Every circumstance will be considered differently. But as I say, against the principles that have been established, whereby it has to be carefully considered for the harm that it could do to have an expert who's partisan, a gun for hire, giving their evidence to the court, where their ultimate aim is to simply resolve the dispute appropriately.
Absolutely, and we'll come on a little bit later about what happens perhaps if you are in those legitimate circumstances where you want to change expert. No expert, Simon, wants to be seen as a gun for hire. I mean, if you get that reputation, then your career could be finished. So you want to protect yourself in those situations. But perhaps what happens in the cases where you are perhaps brought on quite early, because we always give advice on these sessions, bring your whole team early, get some advice before a dispute kind of crystallizes. But perhaps you're brought on as an advisor and you're giving the client some expert advice, and then the role develops into an expert role. How does that work in terms of keeping your independence, and can that be done?
Yeah, I mean, that there has been difficulties where that's happened in the past, and there's case law on that. I don't recall it exactly, but I'm certainly conscious that there are potential conflicts of between those different roles. And I think the way that we tend to approach it is really just to sort of envisage that you have your duty to the court from the get-go. And I think the only way that the compromise or the conflict is dealt with is by being as clear as possible, as early as possible, and just caveating it in terms of well, this may develop in time and so on, but my gut feel is this, and just be honest. Really, I think it doesn't help anybody to give a skewed, beneficial, overly supportive view of a case at an early stage, because later on down the line you're stuck with it's a little bit like giving a budget for some work that you're then stuck with later down the line that's you've exceeded it and it's a problem. So people in their minds will remember the first thing you say to them, and then if that changes later on, it's a lot harder to sort of roll back from that. So I think it's just getting as honest as possible, as sort of independent and broad brush as possible in those early stages.
You're also going to, not be hamstringing yourself in terms of evidence. We all know that cases develop, and what actual physical recorded evidence you're going to be providing in support of your opinion is what it is. And so this comes out in the case law, not necessarily about cases to do with expert shopping, but just the judicial treatment of expert evidence. If they consider that an expert is advocating for their client or their client's case, they're very quick to point it out, and you can immediately see that the evidential weight that they put on that expert's evidence goes through the floor. So it's basically, if only for an expert's reputation, is to be guarded against.
So what do you do as an expert, Simon, to make sure you're staying independent? The cynical amongst could say, well, how can you be independent? The client's the one paying the bills. They want their result at the end of the day. What do you do as an expert to make sure that it's not the case?
Yeah, I mean, I think sort of procedurally, methodologically going through it, I think it's often good to put the hat on of, if I was advising the other side, what would I say? Mm-hmm. That if you're, the other point as well, I suppose, is that you're trying to help somebody to understand you're sort of ultimately meant to be helping the court, but you're helping your client to understand what the court is likely to find. And in doing that, you can say, well, I don't think this is, this just doesn't stand up. I'm sorry, that's not my view. I don't think it's acceptable, or whatever it happens to be. And you're saying that at an early stage because just this main point that if you're saying something that doesn't really stack up, that isn't something that you can stand behind, then you're not helping anybody at that early stage. And I think not minding being difficult and sort of annoying your clients is probably something you have to live with, because you have to deliver bad news sometimes, and I think it is helpful in the long run.
Is it difficult, Catherine, to get clients to understand the independence of an expert?
Yeah, but I mean that should be absolutely one of the touchstones of any solicitor's advice. Is they should be advised as to the merits, and of course, there's plenty of risks that go along with any claim, and you'll never get anyone saying yeah, absolutely you're going to win, etc., etc. But in terms of taking a realistic and considered approach to the merits, means that you should know what the flaws, the potential pitfalls are in your case, and your experts are absolutely crucial to that understanding, because that allows the client to make informed decisions about how they proceed with their cases, and if that involves a different approach to settlement, or a shift in focus, or in fact if you think that there's value in dropping some parts of your case in order to focus on others and redirect resources. All these things have to be considered, and having honest and upfront and sometimes painful to hear news from your experts is just absolutely essential.
I mean, one other point to make there is just that there is often a range of opinion on a certain point, and you can and obviously you're supposed to identify that in your CPR compliant reports, but equally you can discuss that at an earlier stage and say, well, I sit here on this range, or it depends on the facts, but I'm about here at the moment, but this is the range of opinion that could be put forward, and the lawyers may make a decision based on that, in terms of how they pitch their pleadings, more ambiguously or more sort of, it just depends. Obviously they need to base it on the evidence of the expert and the advice of the expert, but there are nuances in how you phrase things can sort of expand or contract depending on the context.
So going back, Catherine, to what we were talking about before, but say for example you have a genuine need to change your expert, perhaps, like you say, they were retiring, or perhaps you wasn't happy with the quality of the report that the first expert did. What is the process, and what are the implications of doing so?
So, as I said, the court has to grant their permission, one, to even present expert evidence, and secondly, if you wish to substitute an expert under the CPR. And so the problem that the courts have is that if, say, there is the inference of expert shopping, they want that to be aired. So the other side will often apply for disclosure conditions to be attached to the substitution order. So they will say, right, I want to see everything that's ever been written, notes, call logs, basically the whole shebang. I want to see everything so that I know that you're not trying to pull the wool over anyone's eyes. And the courts then have to approach that application by towing a line between ensuring that the independence of expert evidence as presented to the court and the duty to the court is upheld, but also that the client has a legitimate right to the privilege that attracts to those documents and those reports. And so it's a very fine balance. And the courts have they've come up with an elegant solution to that, whereby they're never ordering the waiver of privilege. What they basically say is the client wishes to substitute an expert, fine, you can, but if you do, then these things will have to be disclosed, and these are the conditions we attach. Your choice and you have to waive that privilege through your choice. Your alternative choice is to not substitute your expert. So in circumstances where this is absolutely the unfavorable opinion of this previous expert, if in fact that is the reason why you want them substituted, is likely to come out one way or the other. Either you have to continue to rely on that expert if you don't want to disclose their earlier reports, or those earlier reports are going to be disclosed. And that goes all the way back, as I say, to the pre-action stage. So that's something to be very aware of. But that, again, that is in the extreme circumstances where expert shopping is sort of evident. In other circumstances where it is simply that the expert is going to be substituted due to illness or another legitimate reason, the courts will approach the disclosure much more sort of leniently, but they will still look in the Avantage case that Mrs. Justice O'Farrell decided last year, or early this year. One of the experts was replaced due to illness, but she'd been involved from a very early stage in the dispute. So she visited the site a few days after the incident, and she had, kept notes of things like that. So there was no order for disclosure of her reports, but her notes of that meeting, simply for the evidential value that they offered the court, were ordered to be disclosed. Now, at the other end of the spectrum, you have Judge Nisson's decision in Cottesmore, where he very much took the inference that expert shopping was the reason that this substitution was asked for. And he made the quite sort of bold disclosure condition, which was to order the disclosure of an attendance note that had been taken of a call by the client's solicitors, which detailed an opinion of that expert who was going to be substituted. And that's quite extreme, because that's being written by someone else. That's not in the expert's own words, but it was evidence of their opinion previously held. So it is very much the conditions and the circumstances and the consequences of substituting an expert very much will boil down to the motives for it.
That's actually,
Simon, you've got, go ahead.
I was just going to respond to that. Sorry, it's a very good point. This question about what things go into writing and documents and evidence, documentary evidence of your opinion that you might not be aware of. I'm not sure if that attendance note was circulated to the expert, but certainly when you have a conference, someone's taking minutes, that they'll write something or they'll paraphrase you. It's often the case that just because, naturally you will sort of interpret somebody's words in a different way from perhaps the way that they've been intended, you might get a skewed view that's documented. And if you're issuing anything, either your own writing or something that someone else has recorded your opinion as, that's something that I think we in particular are very careful and cautious about, on the basis that at any point, any bit of evidence, even though it's privileged, potentially could end up in front of the court. So you just have to be very careful not to say, that's close enough and it's fine. No, it absolutely has to matter what is being said, recorded in particular.
So Simon, when we was planning this call, you mentioned that you've been in a situation where you've had to replace another expert. So do you want to tell us a little bit about that and what happened and how you handled that to make sure that, expert shopping wasn't going on and you was acting independently and all the other things that we need to be aware of?
Yes, so that replacing another expert has happened a few times over the years. And as I mentioned, I think at the start, it's more of a warning flag, things to watch out for. And I think in those situations, I've definitely tried to understand why it is, and it's partly professional curiosity, but also to guard against situations, why that previous expert has been replaced. In the situation that we discussed previously, it was ultimately this position where the expert that had previously been involved had provided a very supportive opinion of the case that was being put forward, but ultimately the client lost faith in their ability to stand behind those views. I think they possibly weren't hugely experienced in that field, and they were keen to just, almost naturally, that there's a tendency to sort of tell somebody what they want to hear. And you have to fight against that to say, no, this is actually the correct thing that I believe, or I can stand behind, and I know where this is going to end up. And so they ended up shifting to me, but having a report that was sort of from the previous expert that was more supportive than my report ended up being. But I think, as we discussed, that potentially wouldn't be a problem for the expert shopping side of things, because had that report been disclosed, that wouldn't have compromised their case. But I think it's really understanding the reasons for your being substituted, and because often we talked about this before, but it's not black and white. Someone's not coming to you and saying, right, I want a better opinion because I'm expert shopping, with big flashing signs on them. So you've got to be quite careful. It may even be that they don't know that they are expert shopping, even if that is what they're doing, because they say, well, there's something not right, that they're not cooperating, meaning I don't like their opinion, and things can sort of morph into, actually that's how it gets seen by the courts later on. So obviously it's not really the expert, the sort of replacement expert's problem, whether the client is expert shopping or not. It's just a case of being clear at that early stage, and just making sure that you're not walking into this muddled situation of somebody who is expecting to hear something that supports their case, and just wherever there are deviations from your, in your view, from what is being alleged, that has to be flagged up at an early stage, I think.
I think that also goes in terms of being open and honest with your replacement expert, your substitute expert, as to the reasons why they've been brought on board. That equally carries when you are going to the court. The judges are, you sort of think that you're going to get something past them, and it really is very transparent, oftentimes what people are trying to do, and or if you're not being open and honest, that is also quite apparent, and judges don't like that either. So particularly again in the Advantage case, the second expert, it was less clear cut. They weren't retiring because of this. Reading between the lines, I feel like it was in the category of the client had simply lost confidence rather than that they were getting an opinion they didn't like. But it took until the hearing for the applicant to be forthright about why it was that they were looking to replace that expert. And that process of sort of being circumspect about it, I just didn't help at all. And ultimately, I think they made a very fair disclosure order on the basis of the fact that the court finally understood what was going on. So being open and honest at all times, or as far as you can possibly be, then that would be my main advice.
Absolutely. We've got one final question, and then we've got a couple of questions in the chat. If you have got questions for the speakers, do stick them in the chat, because we'll probably take one or two once we've asked this question. Our final question is looking back again at the kind of independence and how that balance is struck, because obviously, Catherine, as the solicitor, you're partisan, you're on the side of your client, but you and the experts are working together as a team, but the experts are independent. How do experts avoid being influenced by their client's case?
I mean, it absolutely boils down to the evidence, and that an expert should always be led by the evidence. And yes, as I say, that can lead to some uncomfortable conferences with the client, where the expert has to, drop the bomb, and everything's turned on its head. So it's simply, you are very aware as the solicitor that and it's in every letter of instruction that I write, is reminding the expert of their duties under the CPR. So you're very aware of that, and you're very aware of not stepping over that line, and making sure. And as I say, it's overall beneficial to everybody involved to know the rights of it, and not to be sort of led down a path of rosy ideals and this is all going to go swimmingly, when simply that doesn't stack up against the evidence. It won't end well.
And Simon, do you want to add something?
Yeah. So I mean, I think that's absolutely right, and it's a case, I think, sort of wearing these different hats and trying to say, to critique, and also we do that internally. We have peer reviews where someone will play devil's advocate and sort of try and tear apart your argument. Ultimately that if it gets to court, there will be a barrister who wants to tear it apart as well. So I think if you're constantly aware that you have to be able to defend what it is that you're saying, I think that keeps you aware that you're not going to really want to say what it is they are hoping that you'll say, if that's something that you don't espouse, that you don't believe yourself, that you're not, you don't want to say what somebody wants you to hear, or rather that can't be the reason that you're saying it. I think that's one other point I was going to make, but maybe I'll come back to that.
So just going into the question and answers from the audience, we've got one question here about how do you evaluate your clients? Perhaps I'll ask you this, Simon. So, perhaps you get a feeling that they're expert shopping, or they're not doing things. So what is the best way you evaluate clients before you start working with them? Are there any red flags to look out for? Are there any kind of things that you do to make sure that client is one you want to work with?
Yeah, it's a good point. I mean, I think obviously knowing the legal team that's worked with people before, that gives you a bit of a feel, the familiarity bit, the reputation and so on. Equally, having just a conference call at an early stage, I think gives you the feel of people's approach, and you can ask some difficult questions. And you can draw inferences from things answered and things not answered. It is very difficult ultimately to sort of find get behind, see behind the curtain, I suppose, of what's going on. But I think you are able to do those in conversations much more easily than you are through exchange of correspondence and so on. But equally, I think you can sort of read between the lines of how the approach has been made, but it's really down to I think this sort of asking probing questions face to face, really.
Our second question, this is about a case that we were in our office were talking about yesterday when we were planning this session. So Pickett and Volkind, in which an issue arose following the inadvertent disclosure of an email. So I think the expert was stepping down because he was sick or something, and then the judge said you have to disclose things, and then an email was disclosed which then suggested the council had edited an expert report. Catherine, have you got an opinion on this case?
Well, absolutely. When you get into the sort of detail, the wording of the email is ever so slightly sort of nuanced, and it isn't absolutely an email saying, well, council asked me to say this when I wanted to say this. It's not so black and white, but it does very much put to the fore that kind of inference, that any kind of influence is tried to be exerted over an expert opinion, is absolutely not permitted, and will be discovered. And so it's not only that you have to respect an expert's independence and absolutely appreciate the rules that they're subject to under the CPR, but it's also that being aware that things can be interpreted. So it's making sure that there's no appearance of it, even if that isn't what's going on behind the scenes. So I think that case very much, and that case was about the writing of a joint statement, which for a lawyer is the most sort of heart racing period, where you've got your two experts in a room having a conversation that you're not a party to. And I don't know if you know this about lawyers, but we're generally control freaks. And not that we'd have any kind of impact on the outcome, but the fact that it's going on and you're just not there, it's unpleasant. But it's absolutely, you have to understand that is the process, and that process is designed to get, or to narrow the issues, or to get the the proper evidence in front of the court. It's not for anyone to use as a way of advocating a partisan position.
Yeah, and equally, I'd say, as you exactly point out there, that it was a joint statement, so that which is sort of sacrosanct more than other aspects of the advice. So there might be more of a discursive, iterative process, and you're saying, well, why are you saying that in the production of reports at an earlier stage? Or, yes, we have further evidence that we can supply that provides the background to that point you've raised there, or something. In a joint statement, there is no involvement whatsoever. And this case suggested that council had been prompting certain interventions, which was obviously far more problematic than having conversations at an earlier stage.
So I guess a warning then of unintended consequences that can arise. We'll take one more question. Perhaps this one is a little bit different, but Catherine, for you, how easy is it or difficult to find a good technical expert, and what should you be looking for when you want to appoint one?
Oh, well, it's a very easy question. I mean, there are great organizations that have panels of experts that they, they've met a certain criteria, such as the ICE and RICS and places like that. So they're always a good starting point, because you know that there is a standard that's been met. I know that a lot of experts will absolutely hate this, but it is often important that we can demonstrate to the client that the expert has given evidence before. And I understand that catch-22 in terms of you can't get a job to give evidence unless you've given evidence. But even if it is to demonstrate that you've received some training, such as companies like Bond Solon offer training as to how best to present evidence and how to not be rattled by opposing counsel, that kind of thing. Because you need to know that they might be brilliant on paper, but ultimately they're going to have to stand up and stand behind this report in an open court or hearing. So knowing how they're going to perform in those scenarios is also important. And then largely it comes down to, word of mouth. Whenever we have a particular issue, we've been instructed on a new matter, the first thing I do is to, email my colleagues and say who recommends who for, a case involving, progressive collapse or subterranean pipes or, all these things. So it's very much that, if you have a reputation in the market and you've performed well in the past, then people remember that.
Absolutely, that was going to be what I would say as well. Ask around, it's a small little world, this one, so people tend to know people and people have a reputation. Do you want to add anything on that one, Simon, from an expert's perspective?
I mean, it's interesting to hear, because you do try and tick those boxes and do the right things, but you'll get a phone call from somebody or an email, and it's sometimes interesting to ask, so where did you get my name? And there are panels, there's directories, but it is often this word of mouth and just repeat business and so on, and hugely valuable, but and hugely sort of precious, I suppose, that reputation and that those connections.
Absolutely. Right, so I think that's it for this morning. Thank you so much, Catherine and Simon, for joining us. It's been a really great session. Thank you to everyone who has been online with us. Our next session takes place in about a month's time. We'll be looking at construction tech, so a little bit of a different spin away from the legal this time, and we'll be sending out all the details for that one in the usual way. So if you're on here, you'll get a notification that that's happening. Thank you again to our speakers, and thank you for joining us. Hopefully we'll see you next time. Bye.
Thanks everyone. Bye.